Yeah. Hey yo, great vibes on 10. True squad in the building. Mr. Clean, Candy Cane, aloe vera, butter pecan, Ronnie Webb, Danger Bun, and Loretta Von Lux. Everybody, everybody sing it loud. Everybody sing it loud. Everybody sing it loud. Great vibes on 10. Everybody sing it loud. Great. Yeah. The van keeps rolling, got the team all set. Chasing down the facts on the internet. Everybody talking, everybody got a claim. But we pull up looking deeper than the fame. Candy cane swinging that candy cane high. Walking through the chaos with a sparkle in the eye. Sweet on the surface, but she call out a lie. Got receipts in the pocket, watch the stories all collide. Must be clean in the middle with the game plan tight. Keeping everybody focused when it turns into a fight. Great vibes on 10, that's the motto every night. Bringing calm to the madness underneath the spotlight. Great vibes on 10.
For the win, let the celebration begin.
True squad rolling and we're doing it again.
Hands up high, let the disco ball spin.
Great vibes on 10. Great vibes on 10. For the win, candy cane, aloe vera, butter pecan in the mix, Ronnie Webb,
Danger Bun,
and Loretta, dropping hits. Great vibes on 10. Yeah, we turning up the room. Scammers get nervous when they hear we're coming soon.
great vibes on 10.
For the win,
That's the slogan we defend. Truth over fiction and we're riding to the end.
aloe vera cool. When the drama gets hot, smooth like a breeze when the rumors get caught. Everybody panicking, everybody losing track. She brings the conversation right back to the facts. Butter pecan steady, never rushing the case. Looking at the details, everybody misplaced. Quiet with the wisdom, always keeping the pace. Then she drops one question and it changes the whole race. Ronnie Webb riding through the storm with style. Got a sharp intuition and a confident smile. People tell stories, she can listen for a while. Then she finds the missing pieces hidden under every pile. Now Loretta Von Lux. Now Loretta Von Lux. Walking in designer flair. Gold hoops in her ears and highlights in her hair. Luxury coat swinging while she surveys the scene. Spot a fake story quicker than you ever seen. Tiny little diva, but her instincts are elite. She can sniff out contradictions from a mile down the street. Gucci on the shoulders, confidence on max, while she's quietly collecting every piece of every fact. She don't gotta shout, she don't gotta bark. One look from Loretta and she's already found the mark. When the scammers start sweating and the stories don't match, Loretta's already smiling cause she solved another catch. Like flat,
Crowd jump,
music hitting hard.
truth hunters,
Fact checkers never dropping guard.
everybody dancing while we're putting clues together. Searching through the nonsense no matter what the weather.
Danger bun. Hopping through the comments every day. Little bunny energy, but great. Yeah. The van keeps rolling, got the team all set. Chasing down the facts on the internet. Everybody talking, everybody got a claim. But we pull up looking deeper than the fame. Candy cane swinging that candy cane high. Walking through the chaos with a sparkle in the eye. Sweet on the surface, but she call out a lie. Got receipts in the pocket, watch the stories all collide. Must be clean in the middle with the game plan tight. Keeping everybody focused when it turns into a fight. Great vibes on 10, that's the motto every night. Bringing calm to the madness underneath the spotlight. Great vibes on 10.
For the win, let the celebration begin.
True squad rolling and we're doing it again.
Hands up high, let the disco ball spin.
Great vibes on 10. Great vibes on 10. For the win, candy cane, aloe vera, butter pecan in the mix, Ronnie Webb,
Danger Bun,
and Loretta, dropping hits. Great vibes on 10. Yeah, we turning up the room. Scammers get nervous when they hear we're coming soon.
great vibes on 10.
For the win,
That's the slogan we defend. Truth over fiction and we're riding to the end.
aloe vera cool. When the drama gets hot, smooth like a breeze when the rumors get caught. Everybody panicking, everybody losing track. She brings the conversation right back to the facts. Butter pecan steady, never rushing the case. Looking at the details, everybody misplaced. Quiet with the wisdom, always keeping the pace. Then she drops one question and it changes the whole race. Ronnie Webb riding through the storm with style. Got a sharp intuition and a confident smile. People tell stories, she can listen for a while. Then she finds the missing pieces hidden under every pile. Now Loretta Von Lux. Now Loretta Von Lux. Walking in designer flair. Gold hoops in her ears and highlights in her hair. Luxury coat swinging while she surveys the scene. Spot a fake story quicker than you ever seen. Tiny little diva, but her instincts are elite. She can sniff out contradictions from a mile down the street. Gucci on the shoulders, confidence on max, while she's quietly collecting every piece of every fact. She don't gotta shout, she don't gotta bark. One look from Loretta and she's already found the mark. When the scammers start sweating and the stories don't match, Loretta's already smiling cause she solved another catch. Like flat,
jump.
Music hitting hard.
Truth hunters.
Fact checkers never dropping guard.
Everybody dancing while we're putting clues together. Searching through the nonsense no matter what the weather.
Danger, 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 bun. Hopping through the comments every day. Little bunny energy, but she's leading the way. Hashtag save the bunnies, yeah, you know what she'll say. Then she'll uncover 3 mysteries before the end of the day. Curly is bouncing, got determination strong. When the trail gets complicated, she keeps moving along. People think it's funny till she proves the rumor wrong. Then the whole room singing to the Danger Bun song. Great vibes on 10.
For the win, let the celebration begin.
True squad rolling and we're doing it again.
Hands up high, let the disco ball spin.
Great vibes on 10. Great vibes on 10. Mr. Clee holding center, keeping everything alive. Headed Kane in aloe vera, always searching what they'll find. Butter pecan, Ronnie Wet, Danger Bun on the run. Loretta Von Lux in designer shades, making fact, checking fun. Great vibes on 10.
True squad to the end. Searching through the fiction, letting real stories win.
Great vibes on 10.
For the win,
That's the slogan we defend.
truth over fiction, and we're riding to the end.
The van keeps rolling, the music keeps glowing, the truth keeps showing. True squad moving. Mr. Clean, Candy Cane, aloe vera, heart of pecan. Rami Wet, Danger Bun, Loretta Von Lux. Everybody singing loud. Great vibes on 10.
For the win, for the win, for the win. True squad in the house.
Great vibes on 10. Great vibes on 10.
Woo! Y'all, we are in day three of this crazy ass preliminary hearing for Charlie Kirk and his alleged the guy that was accused of taking him out. Now listen, I know yesterday we had a lot to say. We was live for a little over 9 hours on yesterday covering this, and I don't mind doing that because again, this right here is a very high profile case if it do make it to trial. Now, before I get to that, everybody welcome in. Thank you for joining your boy Great Vibes on 10 for the win. Rumble, welcome in. TikTok, welcome in. YouTube, welcome in. Now, I don't want people to think that I'm, ignoring other chats. I'm paying attention to the main chat, which all the platforms get filtered into this main chat. So if you got any questions about anything, just drop it in the chat. I will see it, okay? In this main chat over here, all right? Because, y'all know YouTube and Rumble is running on other computers over here, all right? Now, let's give a shout out to TikTok real quick. TikTok, the people that joins over on TikTok, they've been working their ass off. The lead that we're in is, thank you all so much on TikTok for doing that, and also the gift gallery. Y'all really been filling that gift gallery up. And then on top of the heart me's, I really appreciate that. And everybody been sharing the live stream out. That's very much appreciated. On top of tapping the screen. Now, let me put this rule down. When the video is playing, y'all be sure that y'all dropping a heart me. Y'all hitting that gift gallery. Y'all hitting the daily live goal on TikTok only. If y'all don't do that, TikTok will restrict the live, okay? We was restricted 3 times on yesterday. Y'all know that because I had to restart the live stream 3 times, and I don't like doing it. It takes away from the playback time. Okay. Now the hearing hasn't started yet. That's what you see on the screen in the small block on TikTok and YouTube and Rumble. That's what you see in the top right hand corner. So we're waiting for this preliminary hearing, day 3, to begin. Also, y'all just stay active in the chat. And what I mean by that, high engagement. And also make sure you share it out to your stories. On TikTok, share it out to other channels on YouTube and Rumble. Okay. Let me see, little housekeeping. Also, yes, if you haven't hit the gift gallery on TikTok, y'all, please let's hit that gift gallery. Okay. If you want to know what the gift gallery is, just click on my name at the top, Great Vibes on 10, TikTok only. Click on my name. You're gonna see in the middle of the screen, Great Vibes on 10 gift gallery. Click on that. Let's go ahead. You're gonna see some already lit up. You're gonna see a person's name at the bottom. That means they have taken care of their gift already. So just scroll down. If you see one that you can knock out, go ahead and knock that out. And normally throughout the live stream, I will give you a shout outs for doing that. Also, TikTok, if you see this right here going across the screen, if you want a good show, throw one of these gifts. These shows that you see, I put together myself. All right. So yeah, shout outs to your boy Great Vibes on 10 for the win. Y'all, let's be respectful. Trying to get some stuff out the way. Okay, real quick to catch everybody up. Day one and yesterday was, if you ask me, it was. I don't know why we here. I don't know why we're covering. That they even having a preliminary hearing. This is just my thoughts. The evidence that they brought so far, it doesn't prove anything. You had both officers that took the stand. They had two different stories. And what I mean by that, the main one that stood out was the officer on day number one. He said after the incident took place, when he was scavenging the area, he found a black holster on the ground not too far from Charlie's tent that he presumably fits a handgun, but it was empty. And so he, from his remembrance, ghetto ass words, he remembered where his shot came from. So he turned around and looked up at the top of this famous building. So he took off running towards that area to get on top of the building. Didn't notify dispatch, didn't notify other officers, nothing. He did all of this on his own. So when he got on top of the roof, that's where he seen about 10 feet in. That's when he saw this alleged screwdriver that was on top of this roof. No weapon, no nothing. Now he did say that he saw some fresh footprints or something, elbow pads or something up there on the roof. But again, we don't see any physical evidence of that. They didn't present it in court. He turned this potential crime scene over to a female officer to stand there and monitor the area. And this is on top of the building. Day number two, we had another officer take the stand. He said he spotted this same black holster, but it had a handgun on the inside of it. One officer said it was empty, and another officer said it had a handgun inside this holster. So which one is it?
The closest thing to fresh air in this office.
So again, which one is it? Now, the officers couldn't even get their story straight. Now, let's turn our attention over to the videos that they presented in the courtroom. They showed this alleged suspect walking around the college campus, driving in, walking around. One moment he's limping, the next moment he's walking straight. Then they showed a image that presumed to be Tyler Robinson running across the roof. Could nobody make out the face, facial features, none of that stuff. But they assumed it was him. No clear shot of him. No video footage have been presented in the courtroom that Tyler Robinson was the one that actually took the SHOT. Nothing was presented. So why is they pushing for Tyler to go to to go. They're seeking the death penalty towards this 23-year-old gentleman. Why Tyler? If they haven't proven yet that he was the alleged person that unalived Charlie. Then you had the FBI forensics young lady to get up there and, present her argument, her research that she done with forensics, taking swabs and taking the stairwells, the areas around the tent, different things like that. The area where he dropped, allegedly he dropped this weapon at, with a black towel covering this weapon over in the woods across the street. That black towel got more DNA action than the actual weapon itself. She said it was the guy that was with Tyler. Or I don't know if they're lovers, they're friends. I don't know. I'm not going to speak on that because I know where I stand on that topic. But again, they said it was 3 DNA samples that was on this alleged towel. But what about the weapon? No one from on the prosecution side, and you would think with Turning Point USA, they would have so many investigators to help out with this tragic event. Nothing. Why did y'all rush to remove the grass and pave the area where Charlie Kirk was unalived? Yesterday we asked, where's the SUV? Why did y'all sell this SUV? Or allegedly put this SUV up for sale? Because that right there could have been a huge piece in cracking this case. Also, the clothing Charlie Kirk had on, that would have been helpful. But why we behind it? Under the tent, removing cameras and the SD card from it. Why that haven't been brought up in the courtroom? We can only assume, right? Again, we saw video floating across the internet where people are contaminating the crime scene. There's no officers protecting this crime scene. Charlie Kirk is already gone. Y'all had this alleged, shooter in custody already. And we're talking about an older gentleman that was out there hollering saying, hey, I did it, with his pants down. So now your job is to protect the crime scene. You didn't do that. That wasn't brought up in court. And trust me, we sat here and listened to 2 days of this shit. It wasn't brought up. So what case do you have against Tyler? Of him, when was it illegal for a child, a 24-year-old young adult to walk around a college campus limping? That's not against the law. Who and what unalived Charlie Kirk? Maybe we will get something here in day number 3. It's about to start shortly. That's my question tonight. Who and what unalived Charlie Kirk? Because again, the prosecutors, the team from Turning Point USA have not presented enough evidence to prove that Tyler Robinson was the one that unalived Charlie Kirk. Let's go.
Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, Lauren Hunt, David Sturgill of the state, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections.
Now, remember, y'all, TikTok, I do not want to have to restart the live, okay? Remember, while the video is playing, make sure you get your daily heart me's. Let's hit that gift gallery and also the daily live goal, all right? We do not want to get shut down on today. 3 times we had to do it on yesterday. I need y'all help, all right? Help your boy out. If I'm going to sit, here for hours, doing this, so we can figure out what the fuck is going on, because I don't mind doing it. Just help the channel out, all right? And also, if you see the follow button at the top of your screen, please click that follow button, all right? Thank y'all so much for being here.
All right, could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon. Could you state your roles for today's hearing?
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court's standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulties complying with the order?
No.
Thank you both for your cooperation.
Yeah.
As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the 4th floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes.
Listen, right now I'm not taking any requests, so hold off on the requests. We cannot pay attention of what's going on if you're requesting to request to come up. Like what we're going to talk about. We haven't discussed anything today.
a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
I really hope that these two witnesses from the ATF, they don't come up here saying, well, hey, I seen that black empty holster too. Well, when I first walked by, it was empty. Next minute, it was full. I don't know. Listen, I hope these officers got their stories together, because them other two officers, God damn it, they shit was all over the place.
Just want to highlight one issue for the court, because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions, because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state, so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today, and so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
Okay, cool. Listen, let me tell you where the state fucked up already. They presented a video yesterday and day before of Mr. Robinson, allegedly Mr. Robinson in this video. But if y'all noticed, it was different circles being drawn to turn your attention towards certain areas of the video, meaning they altered the video. So again, is altered videos admissible in preliminary hearings and also during the trial? Just my question.
Has come up, and we expect to come up as we enter the second half of this preliminary hearing. Regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles, really, at this stage. One is a gatekeeper role on admissibility. And the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 16.
You're asking, is Charlie and Erica parents there? Now, I do know Charlie parents showed up. I know they were there on day before yesterday. I don't know about yesterday or today. If somebody could give me that information, that would be very much useful, okay?
As we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view.
The world's biggest tournament is bringing together 48 teams from 48 countries with youth. Start juggling 20.
Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Just briefly, Your Honor. I'm sorry, I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those three issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness.
Here we go.
Yes, I mean, I want the press to be able to see it too, but when it's, there is a bit of a distortion when it's at that particular angle. So
yeah,
while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to.
Listen, while he's doing that, listen, y'all, sit down, get ready, get your popcorn out, put your eyeglasses on. If some of y'all are blind, I think y'all got the little dots that's going across your phone. Hell, figure that out. Listen, also make sure y'all liking the live stream, sharing it out. Two is, let's make sure we knock out this live goal TikTok. Let's knock that out so TikTok can leave us alone. All right. So far, y'all been doing it already. Again, welcome in on YouTube, welcome in on Rumble, and again, y'all, thank y'all so much for being here. Again, if you see the follow button, please hit that follow button and tap the screen. YouTube, do not forget to like and subscribe and hit that notification bell. Same thing with Rumble. Again, thank y'all so much for being here. You said I'm busy getting a GED and colorblind certificate. I really appreciate that because I am proud of my GED.
And if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir.
Yeah,
I appreciate
that.
Yeah,
we need to see what y'all see.
Electrum as well. Let's just see if we can get that up because that could cause a delay. I just want to knock this out first. Yes.
Thank you. Now we just getting started, Queen T, sweetheart. We just getting started.
Where would that TV go?
That's right, Vicky. Patriot, thank you so much.
If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable.
Thank you, Queen Momo.
Concept. All right. Yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
Listen, I've seen that a lot, Queen T. I don't know why people are not getting that notification. Y'all just remember when y'all follow the channel on TikTok and also YouTube and Rumble, make sure y'all hit that notification. You want to get all notifications from this channel, okay? Because we're going to be here all week, according to the magistrate here. All right. This is going to end on Friday at 5 p.m. This is Wednesday. All right. And again, we just getting started. All right. And listen, thank y'all so much for being respectful in the chat. I really appreciate that.
Displaying for defense, for prosecution.
We're working on it right now.
Oh, thank you, Valerie.
Yes.
All right. And on the screen monitor here, it looks like something came up. All right. And
You say if this moves forward, will he be the judge? No, he's not a judge. He's a magistrate. So I can't see a magistrate, not magistrate, magistrate, hosting, behind that chair during a criminal trial. I've never heard of it. Has it been done in the past? I don't know. I haven't done my research on it. But more than likely, he's not going to be the person behind that bench.
Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Hell no.
All right.
Everybody
Agent,
else
if you wouldn't
lied.
mind having a seat. To your left is a water bottle.
Just keep it going.
And after you're seated, you'll have to adjust that microphone.
Everybody else
pull it
lied.
down and then pull it toward you to ensure that.
Be quiet. All the other officers lied. So hell, just keep with that train. Do you swear to tell the truth, nothing but the truth? Hell no. Go keep this train rolling.
Your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
Oh, hell.
How long have you been with, is it fair to call that SBI?
Correct, yes.
Thank you,
How long
Candy
have you been
K.
with the SBI?
A total 18 years.
Yes, honey, this is live.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
Damn.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did,
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
No, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns.
Yeah. Shout out to Peanut. Thank you so much for the hearts, the team cheers, the popular votes, the super populars, the popular vote, and popular vote. You said what I'm eating? Some Cheetos. I forgot to eat. Now I'm sitting there.
And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI Public Corruptions Task Force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences, and all those.
Honey, do me a favor. I haven't looked into that. Can you research that for me and get back to me? I'm sorry. She's asking, is Utah a unalive penalty state? I don't know. I didn't look into it. If you can you bring me that information?
Agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a feral certified. It's a 3-day feral.
Thank y'all for answering that question. Again, honey, thank you. Thank you so much.
That's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on
Michelob Ultra Zero, official beer sponsor of the FIFA World Cup 2026.
Technique with more child victims, so just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've... So as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the two pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
We did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department. We also have agents within SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio, video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, then he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
Okay. So while they're getting their little moment in, it looks like what's up on the video screen is the interview room that Tyler Robinson was in. I guess when the FBI agent was conducting this interview. That's what I'm trying to make out of it.
We observed Mr. Robinson. You stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview room in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon.
Bourbon this balanced doesn't just happen. With subtle notes of bright cherry and warm vanilla.
I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
that's correct. Yeah.
So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Listen, everybody, welcome in. Thank you so much for joining this live today. This is just getting started. They're interviewing the first ATF officer, FBI agent for the night. Again, Didi, thank you so much for the hand hearts. I'll save that for later. Don't forget you get your daily heart meets, y'all. Let's hit the live goal, y'all. The live goal. Let's hit that live goal, and then also share it out. Follow, hit that follow button. Blah 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 blah. God damn it, blah blah.
Admitted pursuant to discussion and may be published in the courtroom, and may be recorded or transmitted electronically. Just.
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense. As
Candy and peanut, thank you.
made, and that objection is overruled, and this exhibit is admitted.
In this case, it wouldn't be the 1102 issues. It would be the
what the hell
electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that.
Don't nobody care about no damn room.
All right. All right.
It's empty.
State's Exhibit 15 may be played.
Oh, they finna play it. Well, let me shut the hell up.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with that's like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
We don't see nothing.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
Thank you, Queen Momo.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected.
But you couldn't get Charles Kirk clothing attire. Okay.
When did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case.
Thank you, Queen Momo.
As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning. Shout outs to Candy Cane, y'all. Candy is really showing out. Candy Cane, right now you sitting at the top with a little over 2,000 diamonds, and that's come from the daily live goal. Y'all, thank y'all so much. Candy Cane, thank you so much, sweetheart. Thank you.
Of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
Here we go.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the Sheriff's Department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell?
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
Was Ryan McBride, Chad Grunander.
All right, let me pause this. Sadie, thank you so much for the hand hearts and hitting the data live goal. Now, TikTok just suspended the gifting for 10 minutes. I guess the AI picked up on the video. So this is what I'm going to do. I'm going to turn the video off every now and then, but the audio is still going to be playing. This shit crazy. This is crazy work. This is crazy. So I got an idea. Don't worry about it. Again, thank y'all so much for being here. Thank y'all.
Kimberly Durfler and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George court office, courthouse there. They met and discussed briefly. Just could kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1.
Oops.
Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
All right.
Okay.
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down.
You can't say that bullshit here. They know we lie.
One of the things I learned about in the Google Career Certificate was risk management. There's a project where you go through the...
I think they got us. They know we lying, y'all. how the fuck your ass gonna put?
I apologize, Your Honor. I misspoke. It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record, defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I
they redacted the hell out of it. I just saw your screen, woman. Y'all look all that black area. Look at it. It's a lot of shit covered up. What is that, lady? We can see your screen. What is this? What is this? Is this important? What the hell is that? Took that permanent marker and just, what is this?
If I may approach.
It's right here too.
Thank you.
What is that? I mean, all this shit just. But you want to put the, redacted version in evidence for the trial, but not the unredacted. Just don't understand that. Don't worry about it, lady. We got all the time in the world. It's your show. I need y'all to answer this young lady's question. Drop it in the chat. 1 for yes, 2 for no. If y'all think Tyler is innocent, 1 for yes, 2 for no. Bloom with Mrs. Amanda. Here you go.
To review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
Tell us.
What roof was that bullet found on?
I believe it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south. Yeah, mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up when fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections.
I thought you was there. Listen, let's give a shout outs to Bloom with Mrs. Amanda. Also, let's give a shout out to Sadie. Sadie, thank you so much for sending 4 of the Data Live goals today. And Isabella Coacher, thank you so much for your daily heartbeat. Thank y'all again.
About this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. Are you, you've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
Thank you, Candy Cane. Thank you, Sad Girl.
Who is he in
Amy,
regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but
ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. but it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States.
Question. I have a solid question. Why the fuck was he given immunity? Mr. Twiggs, or Twiggs, however you say his name. Why was he given immunity? For what? For what reason? I am so confused here. Y'all, are we missing something? First, you said a close friend of the family convinced the defendant, the accused unaliver, Tyler Robinson, to turn himself in. This close family friend. It wasn't the family. It wasn't, the cousins. No, it was a close family friend that told Tyler Robinson to turn himself in. Now y'all gave me the Twiggs person here immunities. I do apologize. For what? Why? Why are y'all protecting this guy or this person? I am so confused, y'all, all the way around this case. I'm sorry. I'm so sorry. That's just my thoughts on it.
It's Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before?
Miss Outlaw, false statements in the court, false statements on government documents and stuff. I'm sorry that slipped out. If you haven't been following the channel, I just lost you. Okay.
For his second interview on April 20th, 2026.
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026?
Watch all FIFA World Cup matches on Fox 1. Now available with YouTube.
At the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge. I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview. How the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they.
I don't know. I wasn't keeping up. I don't know if the moderators were keeping up with it. I wasn't keeping up with it. I think y'all completed the live goal, and of course it'll reset itself. All right. So again, for everybody that completed the daily live goal, thank y'all so much. It reset it again and does that. It does that. Long as you live, it's going to reset. But again, thank y'all, especially you, Candy K.
Had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And in regards to this exhibit, is in the
Again, listen to what the officer said, the FBI agent said. Immunity, I do apologize, that was given to Mr. Twiggs. I guess they then this year it was video. I guess it was an interview or something that had him attached to the video that they do not want. They want to submit it to the court, but they don't want the public to see anything that has to do with that statement. So again, what the fuck are they hiding here? And I'm not saying that they're again, this the third day we've been covering this, and everything. There's nothing that have been brought forward. You showed us a video of a soft interview room of Mr. Robinson walking in, turning around, and that was it. Yeah, you showed it to the whole court, showed it to us. Hey, submit that into evidence. What the fuck is that? The stuff that we really want to see, the stuff that we really want to, that, we can say, you know what? Maybe they have a case here. You can't be transparent with the public. You can't show it. What the fuck we gonna do with a still photo?
as State's Exhibit 16, is there any portion of that recorded statement that occurred before the the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense, Mr. Novak.
Thank you. Thank you, Ms. Hunt.
Oh, this motherfucker.
So I'm going to address first, Your Honor,
Get ready.
what Ms. Hunt describes as the procedural issues with our...
Candy Cane, get ready. Your husband up here. Candy Cane, you still in the building? Your man up here. All right, here we go. Thank you, Starry. All right, let's go.
Proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them.
If I had to sit in the courtroom to hear this motherfucker speak in, I'll quit. I will quit. Yesterday, y'all got on this dude's head. Y'all got on his ass so bad on last night. Now his ass back up there. I will quit. I would say I did it. Hell, I unalive Mr. Kirk. Take me to jail. I'll do anything not to listen to this guy. Take me in. Make this shit, hey, cancel this shit out. Y'all got a firing squad here. I'll take that. Imagine him, you being a child of his and he's lecturing you. You did something wrong at school and he come in the house with his briefcase. Now he got your mama said, hey, your daddy here, he want to talk to you. Imagine hearing this guy. You said, oh no, I will run and never come back.
I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared.
Oh, shit.
Ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 11:02 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta and in light of the electronic coverage of this proceeding. And
okay, who said anything about enchiladas? I haven't eaten yet. Why he gotta talk about? Ain't nobody said shit about no damn enchilada. What? Yeah, is everybody good? Everybody good? Y'all listen. Thank y'all for being here. You say he worse than a Baptist preacher on a Super Bowl Sunday.
And in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are 2 other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the 2. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those 2 things that I just talked about are going to be presented to the court by the state. There are also portions of this.
Oh my goodness. Man. Y'all don't sit here and act like it's just me. I'm driving myself crazy with these headphones on. With these headphones, me hearing him thump my damn eardrums. Just say what you have to say. Just say it out and sit your ass down. It's so simple. He testified that, hey, what the group chat said or what everything, the stuff that he read, you just testified. I mean, he just testified. Yeah, that's true. Okay, yeah, I see that. I see that. Is this true? Yes, no. Yes. Is it true? No. Just simple. Sit your ass down. God damn. There have been that should have been hard evidence of Mr. Tyler Robinson taking the shot at Charlie Kirk that nobody hasn't proved yet. Nobody. Half of the stuff y'all was saying, it was hearsay. But they said, hey, hearsay is admissible in this, during this preliminary hearing. Let it have you ate. No, that's why I'm cranky. That's why I'm so sick of listening to this man. I would rather hear my own damn voice than listening to this motherfucker. He's talking in circles. But let me hit play. I'm trying to be respectful.
Efficiently, which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most.
What?
So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court.
Don't nobody care about no damn litigation. Fuck the video. Fuck all this shit. I thought y'all ass gonna bring us something. Y'all ain't bringing us shit. Ain't nothing going on. We don't want to hear this shit. You have no proof that Tyler Robinson did a motherfucking thing. Leave us alone. Leave us out of this shit. Everybody take your ass up. Sir, sit your ass down and shut the fuck up. Thank y'all so much for being here. This your boy Great Vibes on 10 for the win. Thank y'all so much for tapping the screen and giving the daily heartbeats and knocking out that live gift go. Just
Proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, well, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now. But I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before.
You know, the magistrate here, he's been waiting to speak for the past 30 damn minutes while this motherfucker talking circles. He said, yeah, I understand what you said when you first got up here the first 5 damn minutes. I understood what you were saying. This is so bad. I'm about to drink this shit right here. All right. Cause I'm a little thirsty. He has got to the point now where my ass, if anybody wanna talk about listen, if you want some of this chicken broth, just email me your email address and I will email you some. All right. What you mean don't do it? I'm gonna do it.
Before I go to Ms. Hunt. So going to your first point in regards to what this court's position and not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence.
You're asking if it's unsalted? I know it's gluten-free. It was on sale. It expired last year. That's why I had got these 10 for $1. It was 10 for $1, so I got it.
Evidence, typically motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twigg is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you. I,
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here.
Sure.
Because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Okay. Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably, for counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits there are no disputes, these exhibits there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client.
Before Apoquel Chewable for allergic itch, giving dogs pills was a battle of the wits.
Shut up.
Maria.
But I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
No. He just told you. You stood up here for the past 30 minutes trying to plead your case on what should or what should not be shown in the courtroom. via to the public or to the courtroom or should be going into evidence. He told your ass exactly what he just told you. Shout outs to the magistrate up there. Good job for standing your ground because he said all that to get his ass chewed out. Now, sir, go sit your ass down. If he start back talking, I'm ending this live. If he start back talking, I'm ending this live.
There's no ambiguity. I don't think
he's talking end. Listen, thank y'all so much for being here. Thumbelina, Thumblewobble. Thumblewemble. Thank you for them double fireworks.
That what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management, and now I think we're moving pretty far away from the admissibility of this.
No, you doing that.
We could have a conversation later if the court wants to. It's up to
You
the court
doing
about
that.
Case management issues.
Shut up.
But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing. And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court.
Okay, Millie's mom.
Are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed.
I think they got it.
In a manner which protects the parties' rights.
They got it.
All right.
That loud ass tone. They got it. Damn.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a
Thank
hearing
you.
requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview, that it's at issue here, is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today.
I like this guy.
The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is...
Appreciate it. I'm doing good.
We allow the audio to play. If there is some sort of... It sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument at sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar.
Why he keep bringing his ass up there and making a fool of himself? The magistrate here made it very clear the first damn time. When you was up here talking for 45 minutes trying to argue the fact what should be sidebar, what should be open to the court, what should be put on the screen. Now you trying to bring up different case laws. That shit ain't gonna fly in the court. So you had the young dude, the young lawyer from the media side say, you know what? This is what it is. Boom, 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 boom. Cool, got it. Then you gonna bring your retarded ass back up there and just talk some more shit. Now the judge finna get on your ass. You should have listened to me for the first damn time. Don't take your tight suit wearing ass back up there. But no, what do GV know? You took your ass back up there, said some more bullshit. Now he finna chew your ass out. Drinker, thank you for the love, you heart woman. Love you too.
And the court invokes the white noise. That doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing.
Thank you.
So
Then we would like to have a very brief closed hearing to lodge another objection.
Man, goddamn. Somebody keep that motherfucker off the damn mic. Cut his mic off. Sit your ass down. We tired of hearing from you. The whole, goddammit, the FBI, the FBI up there, his ass went to sleep up there on the stand because of your ass. Sit your ass down.
About the publication of this.
I have a GED. What the fuck is, I don't know how to spell motherfucking publication. Don't nobody care. Sit your white ass down. You old. You almost out of here. You trying to get your last words in. It ain't working. Shut up.
This of any portion of this exhibit of certain portions of this exhibit beyond.
Good afternoon. You know why I pulled you over? Not really. I was under the limit. You rolled through a stop sign and... Wait, are you even licensed to drive? Hard to say. Hey, don't... Stop the car! Dispatch, suspect vehicle just took off on foot... You know why I pulled you over? Not really. I was under the limit. You rolled through a stop sign and... Wait, are you even licensed to drive? Hard to say. Hey, don't... Stop the car!
Listen, I cut it off on the second one because I don't want to move people away from the chat. Cuz, shout outs to you for, I think you took the title, for the big booty corgis. And then you dropped your trick or treat. Shout outs to you, cuz. Thank you so much for taking the title on these big ass dogs. Shout outs to you. That's what I'm talking about. If y'all ready, drop a 1 in the chat. Y'all got to give a shout outs to cuz. If y'all ready, drop a 1 in the chat to we ready to continue. Because trust me, more crash outs are coming. Every time this motherfucker get up and speak behind the mic to try to hide shit, I got some shit to say. He said, good job keeping my cool.
That's what I'm saying.
Thank you.
Thank you, Amanda.
All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed, so on the next step, when I make my ruling, the court is ready.
Imagine more productivity with fewer subscriptions. Google Workspace includes AI in your
things we can accomplish.
Imagine him him catching his wife cheated on him. He come home from a long day of a trial. He walks in through the door. He catches his wife in the bed with another guy. He walks in there. This is how this motherfucker's going to deal with this shit. He's going to walk in with his briefcase. Oh, so you're the gentleman that I've been following on howtohookup.com for white bitches. Okay. Let's see. It looks like you. You look like you're about 6'2". Looks correct. You weigh about 240 pounds. 3% body fat. You got green socks on. I can see that. You got purple boxers on. We can definitely see that. I'm gonna show that to the courtroom without being, redacted. That's how that's exactly what's going to happen if this motherfucker catches his wife cheating on him.
Accomplish in the space of 15
Fair enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, let's go a little bit longer. I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there.
Okay. All right, y'all, the panel is open real quick. If they're going to take a break, let's take a 5-minute break. I can get back to it. Let me see. Is they still on break? Oh, yeah. They look like they still on break. Yeah, they still on break. The panel is open. So if y'all want to discuss, if anybody want to discuss what happened so far, which is nothing. If you have a question, and remember when y'all come up, let's stay on topic. Also, if you have any questions about if you think Mr. Robinson here did it, come up. If you don't think he didn't do it, feel free to come on up. Lady, how you doing?
Hey, that
Hey,
poor chair. First of all, that poor chair.
yeah,
Yeah, it's any therapy.
yeah, absolutely.
But I came in late. I know, I came in late. But I was wondering, you know how yesterday they were talking about the evidence about the screwdriver and stuff like that?
Uh-huh.
By chance, did they say anything about if it was, what's it called? If it was evidence or not really there?
What you mean?
Like, how do I say it? So like, if it was tampered or not, basically. Shh, cállate. Shh. Sorry, hold on. So if it was tampered, because you know how like, they said like the gun was, taken like apart
Right.
and wrapped in a towel, and then they had a screwdriver, and then how the thing wasn't kind of making sense yesterday. So I was just trying to catch up on.
Well, the alleged story that went out was when Tyler went up on the roof with this alleged long gun, put the gun together with this famous screwdriver, took the shot. Now all this happened like in between 20 and 30-second time frame. Took the pew pew.
Mommy, help me get these off.
Took the weapon back down. I mean, he took the weapon apart, put it on his persons, left the screwdriver on the roof, climbed down, ran into the woods, dropped the weapon off, covered it with a black towel. When the police officers found or they recovered the weapon was put back together, but the screwdriver was still on top of the roof.
Okay, got it. I just had to kind of clarify because I had kids in the background when I was listening to you for a little while.
That's all right. We just trying to figure out how this weapon got put back together with your screwdriver still on top of the roof.
That's what I'm trying to figure out.
Yeah, I was wondering the same thing.
I mean, they put more emphasis on the black towel with fingerprints. The towel that wrapped that the pew pew was found in. They say it was wrapped in a black item, a black rag, a black towel. It was wrapped in that. But they made sure it was black. Y'all hold on.
Afuera. Afuera. Afuera.
Yeah, because I was wondering if it was wrapped, what was the size of the towel compared to the size of the gun, of the pew pew. That's what I was wondering. Yeah, I was wondering that too, if it was like one of the towels that was at the house. If it was just like a normal size bath towel or just like one of those like face cloths or anything and everything else, because there's different sizes to different towels. So I was just wondering the measurements because when initially it was found, yeah, most of the towels will come into a set anyway, depending on at the ones at the store.
thank you, Peanut, for coming up. Cause it got quiet. Thank you.
I think the towel must have been in the house because it also, according to the DNA expert yesterday, which she was kind of sketchy, but she said that Lance's DNA was on the towel too, so it was like a mixture of DNA. So it must have been at their house. I'm assuming.
Peanut, may I ask, did experts say it was multiple DNAs or it was just two? Because when they initially did the first findings for the towel and the pew, they said there was only 2 set of DNA, and plus with the screwdriver that they found on the roof.
She said it was 3, and then she changed it to 2, and like it was really weird because she had her it was peer reviewed, and the peer agreed that it was 3. And then all of a sudden she changed it to 2. So it was yesterday they went over that, and it was very interesting. So
yeah, because like I said, I just found it a little odd, and I grew up watching like all forensic files to old school Law and Order and everything. Because it's just like when they're going to pick up evidence, they always have a pair of gloves on. If there's no gloves, they use one of their pens. So that's why I was just wondering, is just like, how did this heifer that was on the stand switch from 3 to 2? Ma'am, is it 3? Is it 2? What is happening?
Right, yeah. It was very weird. And then also, like, I was just thinking about this, like the dad, like in the text messages, like you remember those weird text messages where he's talking like it's basically like, it sounds like an FBI agent just made it up, like the text to Lance. So I was just thinking about this, and I'm like, in the text, it says like that his dad wanted a photo of the gun, the pew, because, he had seen it on the media, and it was very unique, and he wanted to see a picture of it, right? Do you know what I'm talking about?
Yeah, because I just thought it was a little odd, because no parent will ask you for a picture of a pew.
Right.
Unless if somebody knows something or if it's one of his that is missing.
And it makes no sense because that picture that they released, it turns out that wasn't actually a picture of the actual pew. It was a picture of a stock image. So it wasn't even a picture of the actual thing. So how would his dad know? You know what I'm saying? Like they just
unless if they do a Google search for a pew that was similar to that, and then grab one of those pictures, saved it on his phone, and then somehow send it in a text. Because that's what I'm thinking.
I don't know. Like the FBI just like took a picture, like they found, and was like, okay, well, let's put this on TV, and it wasn't even the same model or anything. It's so weird.
Yeah, that is weird because the thing is, like, a lot of pews have certain serial numbers and certain different characteristics.
Yep, and his was very, very old. Model. It was like a family heirloom. So, and then when they showed it was like super brand new and like, yeah. And also like they said it was founded in a wooded area. The area they found it in was literally just like someone's backyard with like 2 trees. Like it wasn't like some wooded area that they're making it sound like. And it was like pretty much a wide open field.
Yeah, because when they initially talked about it on the news, I thought they found it deep in the woods by a ravine.
Exactly. You know? And like they had like I think like canines, and I think they searched it like twice, and like they didn't find it, and then all of a sudden the FBI shows up, and then it's there.
Yeah, they magically found it. They're like, "Oh, look what we found."
Yeah, exactly. Right? It's like makes no sense.
It does not. And the other thing that didn't make no sense at all, it was just like they were talking about how this boy managed to climb up on the roof with no ladder and then jump off with no ladder.
Actually, like, so have you seen there's a video of that roof, and you can get to it really easily. Like, there's...
I know, because there was a tree, there's a tree beside that roof, right?
Well, you don't even need a tree, because it's just like... so Brian Enton went there and he did like some videos, and it's literally just a walkway. Like you walk and it walks, it's like, there's like a little chain, but it literally, it's really weird. It's like a bridge, and the bridge just goes right on top of the roof. It's
because when they initially talked about it on the news, they were talking about how because I'm thinking because I was on college campuses, I'm thinking like the roof was like a super massive thing that the only way you would get on it is to be able to grab a ladder, climb from one part of a building to another, right? Because there's certain stairwells in certain buildings. But now how you're explaining it, Peanut, that is just like it was just a little chain thing, and then you could just like walk a couple steps. I'm like, really? Yeah, that's the reason?
Yeah, and there wasn't even steps. It was literally just like a walkway and just like right there. It's like really weird.
Because they were going on like Mr. Robinson was like Tom Holland from Spider-Man, just be like, just like, doing some parkour off of like all the buildings.
Exactly.
So that's why I was just like, yo, this don't make no sense. Because I saw the picture of the size of this guy, and the only closest thing that I would see here where I live in the Great White North is my supervisor, who I'm 30 pounds heavier than him, when he jumped off the top of one of the walk-in fridges. Like, he jumped off and he didn't hurt himself. So I'm like, oh, okay, so it's possible to just leap off the top of the thing. But a lot of stuff, there was a lot of holes in this case. And
oh my gosh, so many holes.
And I still say the Black Widow, Erica Kirk.
Oh my God, yes.
Is the mastermind of all this, because there is no way that fool, Mr. Robinson, knows where her husband was in the University of Utah. Because most schools, if they see you walk up and down the campus police will be like, who's you?
Yeah, and they say they had no drones up there that day, and there's all kinds of little drones. Have you seen the videos of all the little drones sneaking around? Like,
yeah, because
there's drones everywhere that day.
Because there's no way nobody was flying any drones over that.
Right, and because they were doing, they were collecting like people's cell phone information. Like they were doing the, I don't know what's it called, geofencing. They were geofencing, like, and that's what they use. They use those little drones to like.
Because the thing is, if people were using their cell phones around that specific area, there's certain cell phone towers that your signal will bounce off it, right?
Yeah.
And when they were trying to search through everything, they were like, oh, they didn't talk about the crowd and everybody that had their cell phones that was recording everything, right? And people that were sending messages back and forth. Because when I initially saw the first video with Mr. Kirk and when it happened, the pop, and everything else, like you see the security that was behind him mysteriously disappeared.
Wait, GB wants to talk real quick.
Okay, sorry, GB.
No, it's okay. Yeah, they suspended the gifting for 10 minutes because I don't know how they. I already paused the video. They sit there 3 minutes after I paused the video.
Oh my God!
They hollered at me in the chat. GB, turn your gifts on. I can't. They suspended it for 10 minutes.
That's so lame.
I know.
Y'all go ahead.
They're just petty. They're petty right now.
And I'm also thinking like, they're showing all these videos of, what supposedly is Tyler Robinson, but it's like, they should have his cell phone. They should be able to show us through his cell phone, like location and all this stuff. Like, why don't they have all that? They're just showing us the videos of some random dude.
Yeah, because the thing is, with every cell phone, doesn't matter if it's an iPhone or an Android, if you're at certain places, the map will pop up of the location where you're at. So they didn't even look into that. They were trying to look at, like, oh, well, he deleted messages. Your messages, even if you delete it, it will still be on your cloud.
Exactly, yeah. And like also... like Discord, like that was so weird. Like, GV, did you see that email I sent you? That was bizarre. So like Discord at first came out and said like, oh no, like, he didn't send any messages through us. And then all of a sudden the next day they're like, oh, actually he did, and we deleted his account, and like here's the messages, and we're working with the FBI and da-da-da. But those messages that were sent would have been sent after he was already in custody.
Exactly.
So
Because
it doesn't make any sense.
because unless if his account was still open, or in some rare cases, like certain prisons allow you to have a cell phone, so everything will just stay kind of connected, right? Because
Yeah.
even during the times when I used to when I watched Love After Lockup, everybody will have their cell phones and they're still doing video calls. They're still chatting while they're in prison. They're still doing everything else. Even with the stuff with the diddler, like same thing. He had a cell phone. He was able to talk to people. He was able to jump on social media and everything else. So there's a lot of holes of just like they didn't look at the cell phone signals of where he was, like which locations he popped up at and everything else, because a lot of stuff didn't make no sense, and the FBI is super sloppy.
Super
sloppy. Like this
It's
Harry,
crazy.
the last 2 days I've been watching this Harry and GV crashing out.
I know, it's great, right?
I never laughed so hard. I was in tears.
I know.
My
His
face
crash
started
shots are
hurting.
the best.
I was in tears. My face started hurting, and I was trying to do homework, and I couldn't even see. I'm like, yo, I can't see nothing. I can't see anything at all. My face is hurting.
I say shit y'all will be thinking.
Yo, because that one lawyer, every single time, he was worse than my professor. When I went to Humber College, that was it, doing a 3.5-hour lecture for business law, because every single time he had to get up and talk about absolutely nothing. So I said masterpiece theater circus.
Like, dude, he was talking in circles and trying to argue the fact to hide shit. Like, dude, just shut the fuck up, man. You said what you said. Then he was trying to tell the judge, the magistrate, how to do his fucking job with the sidebar and shit. So when the news reporter, I guess it was one of the lawyers from the media, came up there and said, okay, y'all, this is how it's done. Like, he had to correct him. And then a judge had to correct him. And he still kept talking.
Did you see the judge who was giving a side eye?
Yeah.
Going like, yo, bro, hurry up. Like, wrap it up.
Yeah, like, you took up damn near 3/4 of the hearing just running your damn mouth. So again, listen, Letty and who?
Rory.
Yeah.
Rory.
Rory.
Yeah.
Rory,
That's my name.
good to have you up here. Thank you so much for coming up here.
Thank you.
All right, listen, y'all. And again, thank you, Letty.
Thank you.
No problem. Let me ask y'all a question. Let's see if the gift had been turned back on. Somebody send a heart me, or somebody send something. Somebody send something to see if it'll allow you. Not yet. Weak ass shit. Well, right now, y'all, the video is playing. It's playing, so we just waiting for them to come back. It's playing. So that right there was that's a long ass break. I think they needed that break from him because he was talking too damn much. So let's see. I'm trying to see what you would think 10 minutes would have went by. Do they do it the duration of the live? I don't know. I think it was 10 minutes. You said we all needed a break from him. Shit, just if you believe Mr. Robertson did it, put a one in the chat. If you think he is responsible, he's responsible for Charlie Kirk not being here, drop a one in the chat. Just the ones that believe it, okay? You mean to tell me none of y'all? Okay, Laura said half. You mean to tell me none of y'all believe that he did it? And we're just listening to what they brought to the court so far? Wow. Some of y'all said, I don't believe he did it, but I believe he had part in it. So why him? Why him? Out of all these people that's around here, why did they pick him out? Okay. You say he wants to be seen? Paid off / Rael loves trans. Laura said, yes, I do. I think he was supposed to commit unaliving, but he didn't. Okay. Peanut, we can't put a live video on 2 times the speed. Wrong place, wrong time. Multiple people claim to have done it. Y'all believe he did? No, most of the people here doesn't believe he did it. They think he's part of it, but they don't think he did it. So all right, so listen, y'all try now. See if the gifting work. Can somebody try it now? I think they suspended it. Listen, if you see a follow button at the top of your screen, click that follow button. And this is a good time to do it since they're on break. If you see the follow button, go ahead and hit the follow button right now. Oh, we finna fix that problem. All right, cool. No, don't keep tapping. I'm finna restart. All right. Listen, y'all, for do a quick restart. I'll be back in 45 seconds. TikTok only. All right. Oh my goodness. I don't know why they did that. I don't know why. So this is gonna be our little intermission right here. So we'll just play some music.
Everybody sing it loud. Everybody sing it loud. Everybody sing it loud. Great vibes on 10. Everybody sing it loud. Great. Yeah. The van keeps rolling, got the team all set. Chasing down the facts on the internet. Everybody talking, everybody got a claim. But we pull up looking deeper than the fame. Candy cane swinging that candy cane high. Walking through the chaos with a sparkle in the eye. Sweet on the surface, but she call out a lie. Got receipts in the pocket, watch the stories all collide. Must be clean in the middle with the game plan tight. Keeping everybody focused when it turns into a fight. Great vibes on 10, that's the motto every night. Bringing calm to the madness underneath the spotlight. Great vibes on 10. For the win, let the celebration begin. True squad rolling and we're doing it again. Hands up high, let the disco ball spin. Great vibes on 10. Great vibes on 10. For the win, candy cane, aloe vera, butter pecan in the mix. Ronnie Wet, Danger Bun, and Loretta, dropping hits. Great vibes on 10. Yeah, we turning up the room. Scammers get nervous when they hear we're coming soon. Great vibes on 10. For the win, that's the slogan we defend. Truth over fiction, and we're riding to the end. Aloe vera cool when the drama gets hot. Smooth like a breeze when the rumors get caught. Everybody panicking, everybody losing track. She brings the conversation right back to the facts. But a pecan steady, never rushing the case. Looking at the details, everybody misplaced. Quiet with the wisdom, always keeping the pace. Then she drops one question and it changes the whole race. Ronnie Wet, riding through the storm with style. Got a sharp intuition and a confident smile. People tell stories, she can listen for a while. Then she finds the missing pieces hidden under every pile. Got Loretta Von Lux. Now Loretta Von Lux. Walking in designer flair. Gold hoops in her ears and highlights in her hair. Got your Rico swinging while she surveys the scene. Spot a fake story quicker than you ever seen. Tiny little diva, but her instincts are elite. She can sniff out contradictions from a mile down the street. Gucci on the shoulders, confidence on max, while she's quietly collecting every piece of every fact. She don't gotta shout, she don't gotta bark. One look from Loretta and she's already found the mark. When the scammers start sweating and the stories don't match, Loretta's already smiling cause she solved another catch. Lights flat, crowd jump, music hitting hard. Truth hunters, fact checkers, never dropping guard. Everybody dancing while we're putting clues together, searching through the nonsense no matter what the weather. Danger, 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 danger bun, hopping through the comments every day. Little bunny energy, but she's leading the way. Hashtag save the bunnies, yeah, you know what she'll say. Then she'll uncover 3 mysteries before the end of the day. Curly is bouncing, got determination strong. When the trail gets complicated, she keeps moving along. People think it's funny till she proves the rumor wrong. Then the whole room singing to the danger button song. Great vibes on 10. For the win, let the celebration begin. True squad rolling and we're doing it again. Hands up high, let the disco ball spin. Great vibes on 10. Great vibes on 10. Mr. Clee holding center, keeping everything alive. Headed Kane and aloe vera, always searching what they'll find. Butter pecan, Ronnie Wet, danger bond on the run. Loretta Von Lux in designer shades, making fact, checking fun. Great vibes on 10. True squad to the end, searching through the fiction, letting real stories win. Great vibes on 10. For the win, that's the slogan we defend. Truth over fiction and we're riding to the end. The van keeps rolling, the music keeps glowing, the truth keeps showing. True squad moving. Mr. Clean, Candy Cane, aloe vera, heart of pecan. Ronnie Wet, danger bond. Loretta Von Lux. Everybody singing loud. Great vibes on 10. For the win, for the win, for the win. True squad in the house. Great vibes on 10. Great vibes on 10.
Okay, so it looked like that helped out. Looked like that worked. Queen T, thank you for the 9. Love you so much. I really appreciate that. I hate when I have to do that, restart the platform. It messes up the push out, and I don't like that. I don't like it. Again, right now, y'all, we just waiting on the video. I mean, we just waiting for the trial to start back. Well, the preliminary hearing to start back up. Just to catch y'all up, it wasn't too much being said today. Right now, they're on break. They should be back shortly. It wasn't much being said. Don't know what else to say. So we're just waiting patiently until they come back. Again, it's nothing. I mean, we already recapped Monday and yesterday. So. Hopefully, when they get back, they can actually ask this this FBI agent some questions that the public is looking for. Now, it was something this young lady said that was up here before I restarted the platform. She asked, well, she made a statement as far as, logging the cell phone location. You never heard that come up? It's so much shit you never heard come up that I'm just me myself. I'm confused on. I thought I turned this. There it is. A lot of stuff didn't come up. Just a lot. Things that you would think that would be important to this preliminary hearing. You would think it would be important to this if they decide to take this to trial with a grand jury. And so far, we don't see nothing to tie this man, this young man, to this weapon at the time that they allege this shot took place. They have not proven that yet. And it's sad because this is what they've been putting on the news. This is what they've been putting on social media for the past, 10 months? 10, 11 months? 10 months, I think. And again, the majority of the people is saying, hey, this is bullshit. You said it will go to trial. I mean, I hear you, but I still don't see the evidence. They haven't presented yet. Enough. Just enough evidence, enough proof that this man did it. Again, I may have missed something, but I don't see it. The last few days has been a whole shit show, and today is starting off as a shit show. Like what are we doing here? Nothing about this is making sense. Nothing is adding up. Nothing is being nothing. I'm sorry. Again, you may disagree with me, but again, I don't see it. I don't see this going to trial. But I could be wrong. But if you take this to trial based on the evidence you brought forward so far, what are you going to use? How are you going to convince the jury, a grand jury, that this man was behind the weapon that took the shot at Charlie Kirk? What video do you have of this man laying down, prone on the rooftop, firing his weapon? Again, y'all, I could be wrong. I just don't see it. You said video evidence, DNA, turn himself in, partner testimony, text message. This is only day 2. No, this is day 3. Video evidence. No, they did not show video evidence of him behind that pew. They didn't even show video evidence that he had that particular weapon on him. Now they show him walking with a limp, but they did not show video evidence of that pew on his persons. They didn't show that. DNA. It was several DNAs they found on a towel. Okay? On a towel. You said he was there 4 times that day. He lives 4 hours away. Right? They showed that. They showed him walking around the campus, but they didn't show him taking the shot. What's really going to hurt them, again, you had 2 different officers. There at the scene gave 2 different stories. Now, you said text messages with his partner. Right. Now, those messages with his partner, was that done out of his own, free, what did he just send those out, or he was told to send those out? Like, again, you got to look at it from all sides, right? You just can't see. I mean, you just can't look at one side what the prosecutors are giving, because number one, they're failing big time. But again, those text messages don't mean anything. The Discord messages doesn't mean anything. Okay. Again, nobody has placed him behind that gun, laying prone while Charlie Kirk was speaking, and he took that shot. Nope. That's if you could show me a video of him doing that, my whole narrative is going to change. Show me that. Not him just walking around, limping around, hopping off buildings and shit. That still don't prove anything. You said, why was he still in a maroon shirt on 7/12 when he went to the police station? I don't know. I can't answer that question. But listen, y'all, hear me out. You said, how do you know they don't have the footage? If they did, they would have presented that footage on yesterday, early yesterday, in part 1 on yesterday, when they was showing everything else. They would have showed it day before. Now, will they show it in the future? No, I don't know. I don't know. Maybe they know something we don't know, but they hasn't presented it yet. That right there should be one of the first ones they presented to the court. To say, hey, this is why we have a strong case here, to take this to trial. There he go. There he go putting this pew together. There he go laying down, prone position. There he go, eye behind the sights, finger behind the trigger. It don't show that. Yeah, I know you have to show proper cause, but also doing that proper cause, if you're going to help, they showing all what they have. When it comes to the videos of him, the same videos that have been flowing around social media for the past 10 months. But none of the officers, none of the FBI agents, even the medical examiner, none of them said, hey, we got footage of him taking that shot. We ain't gonna show it yet, but we do have footage of him taking that shot. But again, I'm not a lawyer. I'm not a legal counsel. I'm just going off what has been brought to the table so far. Jenny, you say you got a question. Whoa. Hold on, partner. Hold on. You just going to come in talking like that? It be the ones that be making these fake ass accounts. Oh, that's what your channel is about. Y'all do me a favor. Y'all click on his channel. I'm going to notate this channel. Because what you have posted on your page. Y'all be so damn stupid. Y'all got to be careful what y'all post on your page. Y'all so damn stupid. Go ahead, Gina. What's the question? Oh, he got up out of here. You said prosecutors never show all their cards. I get it. But again, the evidence they brought forward is it's not working. And they still on break, y'all. Patriot Mama, how you doing? They still on break. The video is live. So again, y'all just grab some popcorn and take a seat. Right? This is live, so it's nothing going on. You said they have to give it to the defense. B. Gina, what's your question? Okay. Just sent you a message, Queen T. Okay, they back, y'all. They back. Here, let's go.
Appreciate your patience. Sometimes it takes time to save time, and so that was the intent of this court in addressing what is before this court as it relates to State's Exhibit 16. Counsel, this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail. All right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees, it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again. To be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Oh, hell. Here he go again.
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because
Sure.
I do think a closed hearing is appropriate. There are, okay, setting aside the 1102.
Real life isn't always kind to my floors.
Shout outs to
But I
Candy Loop.
rejuvenate all floors restore to help keep them looking like new.
Shout outs to Cuz.
With just one coat.
Video by Mr. Twiggs attributed to Mr. Robinson. Okay, Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay, I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even
chasing down the facts on the internet. Everybody talking, everybody got a claim, but we pull up looking deeper than the fame. Candy cane singing that candy cane high, walking through the chaos with a sparkle in the eye. Sweet on the surface, but she call out a lie. Got receipts in the pocket, watch the stories all collide. Must be clean in the middle with the game plan tight, keeping everybody focused when it turns into a fight. Great vibes on 10, that's the motto every.
Shout outs to you, cuz. Y'all, is he still talking? Lady, thank you for the pearl child. Is he still talking? Thank you, Queen Momo.
In this courtroom who will go outside and speak on what we used to call television.
Man, shout outs to you, B. Genie. Thank you so much for the 2 galaxies. Thank you, thank you, thank you, thank you. HR is in the building. You said, notice how they aren't objecting whether or not he was actually there.
The 14th Amendment.
So, and I appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it in the
It is not. It is earlier, and it's also the 2 other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed.
Oh, really?
We did not put the entirety of them in.
Really?
And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And I don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as previously referred to as confessions and certainly would refer to here in this proceeding as confessions, we are so acknowledging that they are statements of a party. We have not filed anything in this case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's so I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand, what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. And I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twig's video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates
in the mix, Ronnie Wet, Danger Bun, and Loretta, dropping hits, great vibes on 10. Turning up the room, scammers get nervous when they know we're coming soon. Great vibes on 10, for the win. That's the slogan we defend. Truth over fiction, and we're riding to the end. Aloe vera cool, when the drama gets hot, smooth like a breeze when the rumors get caught. Everybody panicking, everybody losing track. She brings the conversation right back to the facts, but a pecan steady, never rushing the case. Looking at the details, everybody misplaced. Quiet with the wisdom, always keeping the pace. Then she drops one question and it changes the whole race. Ronnie Wet, riding through the storm with style. Got a sharp intuition and a confident smile. People tell stories, she can listen for a while. Then she finds the missing pieces hidden under every pile. Got the red of our love. Walking in designer flair. Gold hoops in her ears and highlights in her hair. Luxury coat swinging while she surveys the scene.
That was 10,000. That was a total of 10,000 diamonds. She's sitting at number one right now with 12,000 diamonds. Those two jets, BG, just to let you know, one of those took the title. The other one you threw was extra. You just, man, listen, y'all, that was 10,000. Whatever you do for a living, hire me. Auntie Mac said no, but seriously, question, no. His assassination was publicly aired. Why can't this be? Auntie Mac. Now, my question to you. What unalived him? Was it the bullet from the gun? Or was it something else? What did it? When you get a chance, go find the video, slow it down. Just slow it all the way down. You're going to see some things. Allegedly.
To that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then, in the future, move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations, because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963. Sure. citation to
What the fuck they got to do with anything? Notice the long pause. The Supreme Court used that term in 1963. And then complete silence. Awkward ass moment in that courtroom.
state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right. Thank you. I appreciate both parties advocating and arguing. It's helpful for the court. All right, so in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to. Sorry, starting on page 7, right after 8, is that at 8?
Add over 45 streaming services, all in the YouTube app.
Well, let's start. Starting on page 6. Now, let me go back here. Starting on page 6, after 6 minutes and 56 seconds. Going to 20 minutes and 27 seconds. For reasons such as 403, under Rule 403, And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Can you state those times again, Your Honor?
6:56 until right the line before 2027. Or 2027, just so until 2027. Is that? And then and then what the court indicated previously from $32.55 until $35.48.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for Your Honor's consideration.
Right, so kind of going through my three-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video. Is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance and everything that everything that Mr. Novak noted. I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
Thank you, Your Honor. I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed.
Listen, this is where I'm confused, y'all, and somebody please help me out. Why is they putting more emphasis on the text messages than the actual weapon itself? The location of Mr. Tyler, if he was up there on that roof. If y'all notice, they talked about it, but they sped past it, right? It wasn't no in-depth questions. Now, again, when it comes to these text messages, we've been this whole time. That's all they've been just really been pushing at. I don't understand that.
Filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I have, Your Honor.
Thank you. And all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and that your mic's muted.
Yes, we just want to say that we.
Where was where was that energy with the weapon? The timeline the officers gave and the stuff that they would not show up, show to the public. Where was that energy? But again, a lot of people have questions about who sent these text messages. The Kirk family want to push that.
Totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite to Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a...
Now this is a real kitchen. Full speed, running on Genius, orders hitting instantly.
But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole of what were all the different opinions in Rideau and why is Estes citing to a dissenting justice. But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to 20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 3255 until 3548. Does that comport with what I previously said?
Yes.
All right. And then from 3548 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes, under my analysis, under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act, but I'm trying to act in the interest of justice in making this balancing act, and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
If you're going to have just a moment.
Of course. And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
Judge, it's the state's position that we close for today, come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit, which we think the state will offer through Mr.
Oh my
Davis.
God,
I'm sorry.
oh, hell no, man. What the fuck, man? Get your ass on, boy. You get your goddamn ugly ass on.
Redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements that the prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank you,
problem.
Mr. Novak. And if you wouldn't mind, obviously, sending a copy to the state as well.
Oh, of
so
course,
it's not
of course.
Ex parte. All right.
So is the court referring to a formal filing?
No, just if you
A bench memo.
A bench memo, and that all sides can have a take a look at, just to prepare, again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Not from the state.
All right. To defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
All right, listen, y'all. I'm not even going to open up the panel, okay? Because again, I'm hungry. I'm hungry. We've been live now for 4 hours, and we just going to end it on this note. Nothing was brought forward today. It was just a bunch of yibba yabba, trying to see what's going to be pushed out to the public or not. What was going to be redacted, what's going to be unredacted, according to these messages, these text messages, these messages in the Discord. That's the last 4 hours. That's what it's been about. That nothing more, nothing less. I mean, what is there to talk about? 4 hours of some damn text messages. And I think he did that shit on purpose. Thank you so much, Kiki. He did that shit on purpose. You said prosecution chose his defense. Wait. Chose his defense. Addis Elizabeth Lane tried to get him private lawyers. And I seen that earlier. You're right. But again, y'all, thank y'all for being here. Thank y'all for all the gifts, all the loves. Thank y'all for the daily live goals. Thank y'all for sharing the live stream out. Thank y'all for being here. Thank y'all for allowing me to stream this for you all. Thank y'all for entertaining the platform. Just thank y'all for everything, okay? But we've been going and wrap this up because I'm hungry. So again, you say he got screwed. His defense sucks. We're going to talk about that tomorrow. And now what I'm going to do is I'm going to make a short video and upload it. Pretty much what happened today, and it's nothing. And then y'all can drop y'all thoughts and everything in the comments. So again, I don't even know why I'm even putting this up here. If you want to catch this crazy ass replay, there it is right there. I don't know why, because there's nothing to see. Again, moderators, thank you all. YouTube Rumble, thank you all. And yeah, y'all, I'm hungry. I got to get out of here. Thank y'all for being here, and y'all, we're going to resume on tomorrow. It's your boy Great Vibes on 10 for the win.
Rolling, got the team all set. Chasing down the facts on the internet. Everybody talking, everybody got a claim. But we pull up looking deeper than the fame. Candy cane swinging that candy cane high. Walking through the chaos with a sparkle in the eye. Sweet on the surface, but she call out a lie. Got receipts in the pocket, watch the stories all collide. Must be clean in the middle with the game plan tight. Keeping everybody focused when it turns into a fight. Great vibes on 10, that's the motto every night. Bringing calm to the madness underneath the spotlight. Great vibes on 10.
For the win, let the celebration begin.
True squad rolling and we're doing it again.
Hands up high, let the disco ball spin.
Great vibes on 10. Great vibes on 10.